liability in general. When we're talking about physical persons in relation to liability in general, we're referring to natural persons or individuals as opposed to legal entities, which could be private or public limited companies. And physical persons are personally liable with all of their assets for the debts that they incur themselves. And when a company gives credit to a customer, it's important for the company to find out who is liable for the debt, thus meaning who can they claim the money from when the amount is due. This also applies to other situations, for example, when a bank gives credit to a person or a company, or even if an individual lends money to a friend. And the second part of the liability rules concerns what the debtor is liable for. In other words, what assets the company or the bank or the individual may lose if there's a debt collection case. And we've got two terms that we use. So anyone who has a debt is called a debtor, and anyone who has a claim on another is called a creditor. So as a debtor, you can be liable in several ways. So there's personal liability, and it means that as a debtor, you're liable with everything you own. So you have a financial obligation which may be satisfied out of your assets. And this means that if a physical person is personally liable, the person may lose both private assets, such as, for example, a house, as well as assets he may have in connection with, for example, a sole proprietorship. So thereby they could lose inventory or production, machines, or even the office building. Then there's limited liability, which is another kind of liability, and this is where a person's financial liability is limited to a fixed sum, most commonly the value of the person's investments in a company or a partnership. So if a company with limited liability is sued, then the claimants are suing the company, not its owners or investors, if that makes sense. And a shareholder in a limited company is not personally liable for any of the debt of the company other than for the amount that they have already invested in the company and for any unpaid amount on the shares in the company, if there even are any. And by contrast, sole proprietors and partners in general partnerships are each liable for all of the debts of the business. And then there's joint and several liability. And in the case of joint and several liability, there are several debtors in contrast to the others. So each debtor is liable for the entire debt. This means that the creditor can claim the entire amount due by the debtor who is the most solid, who's got the most money, or is the easiest to get the money from. Then there's pro rata liability. And in the case of this kind of liability, there are also several debtors. They are liable for their own share of the debt. So the proportion of the share will be agreed with the creditor as a fixed fraction or percentage. And a creditor cannot get more from the individual debtor than the share he's liable for. And then there's direct liability, which means that the creditor, without first having established whether the debtor, for example, a partnership can pay its debt, may claim it directly from the shareholder's personal wealth. And lastly, there's indirect liability. And in the case of indirect liability, the creditor must first seek to obtain his claim from the debtor. Only if it turns out that the debtor is insolvent, the creditor can go to the shareholders in person. However, this does not apply to companies with limited liability. So now I'm going to be talking about marriage. So in Denmark, two persons of either the same sex or opposite sexes can marry and thus become spouses. And the wedding can take place both in a church or as a civil marriage. And regarding this, there are several laws that affect couples or marriages in general. So the first one I'll be talking about is Lov om ægteskabsindgåelse, opløsning. And this states the conditions for being able to enter into marriage, the rules of marriage, and regulations on separation and divorce. Så der er ægtefællesøkonomiloven, which regulates the spouse's community property. And the Act contains provisions on the spouse's maintenance duty, their right of disposal and liability, and also if they've got any internal agreements on separate property and division of community property as well. In the case, and this is in the case of a divorce or a death of one of the spouse. And the point of this is to secure the individual's right to dispose and making sure that it's not restricted by being married. However, when the community property comes into effect when getting married, there are a few situations that act as restriction on the parties' independent right to act freely, both in regard to debt formation and, for example, it could be in regard to sale of assets. Then there's a lov om ægtefælleskifte, and I won't be translating these like the headlines of the laws because I don't know what the exact translation is. However, this one sets out the rules that apply when a marriage ceases due to separation or divorce. And to change, or skifte as it says in the word, it means sharing or distribute. And in case of divorce, the couple's community property must be changed, thus meaning shared or distributed. And the same applies to death. So after a married person is dead, the first change which is made is a division of the community property. And the part which the deceased should have had becomes the estate of decedent. And this is changed by dividing it between the deceased heirs, in which one of them is the spouse left behind.
Theme 2. Proprietary relationship between spouses. When entering a marriage with another person, it triggers more legal duties and rights, both when entering a marriage and ending of a marriage. A marriage forsørgelsespligt. When two people get married, they enter a community. The Ægtefælleøkonomi Act's starting point is that both parties are equal and there's a mutual duty of support while the marriage is happening. The Act about ægtefællens økonomiske forhold, paragraph 4, says that under ægteskabet har ægtefæller pligt til at forsørge hinanden. This means that both spouses are obligated to raise money or and otherwise contribute to the family's subsistence to an extent that corresponds the family's living conditions. The duty of society to help a person financially is the secondary in relations to the duty of a spouse obligations. A marriage creates a common interest in several contexts. In the couple's internal affairs, will there often be a mixture of their finances, and in relation to their creditors, may the spouses have a particular interest in arranging it, so it is harder for the creditors to get their money if the economy is tight. Theme 2.1 Community of Property. Before two people enter a marriage, they each have different assets and liabilities, such as furniture, cars, books, and debt that are brought into the marriage. It is a myth that both people own each other's assets and liabilities that are brought into the marriage. Each person is liable for their own debt and assets in a marriage. And this can be found in the Ægtefælleøkonomi Act, paragraph 1, 2, and 3. The paragraph 1 says that under ægteskabet råder hver ægtefælle over sin formue, uanset om formuen er erhvervet før eller efter indgåelsen af ægteskabet, dog med de begrænsninger, som følger af stykke 2, paragraf 2 og kapitel 2 og 3. And subsection 2 says that en ægtefælle skal råde over sin formue på sådan en måde, at den ikke utilbørligt forringes til skade for den anden ægtefælle. And the paragraph 3 says, under ægteskabet hæfter hver ægtefælle med sin formue for sine forpligtelser, uanset om forpligtelsen er opstået før eller under ægteskabet. Separate control and separate liability. Each spouse therefore owns his or her own wealth independently of the marriage. Even if people are in a marriage, they are still two financially and legally two independent persons who can make agreements about their assets, for example, sell them, mortgage them, or leave them away. And a person can also create personal debt. This is called separate control for assets and separate liability for the debt financing. Spouses may act with each other but a secure proof of agreement is required if it violates the creditor's interest. Spouses can share an asset, which is called co-owned assets or joint ownership. For example, both parties can stand on the sales contract for a car or a house. The spouses can also collect debt, and unless otherwise agreed with the creditors, are they joint and severally liable. A spouse's assets and debt is included in a community property and a joint community property. In a marriage consists of both spouses' community property. Yes. The spouses having a common community of property really only becomes a reality in the moment they decide to get a divorce, separate, or in case of a death. At the end of a marriage, it is a common rule that equal division of the wealth takes place. It happens through a division of community property. The ægtefælleøkonomiloven paragraph 5 subsection 2 is the main rule, and it says that en ægtefælles formue, der efter styk 1 ligeledes betegnes delingsformue. Ægtefællernes delingsformue udgør et formuefællesskab mellem ægtefællerne. And there are only 2 exceptions which limits the division of the community property. Partly, certain assets are excluded from the law, and partly are separate control and possible related debts not a part of the community property. Ægtefælleøkonomiloven paragraph 5 subsection 1 says, ved separation eller skilsmisse deler ægtefællerne deres formue lige, medmindre de har indgået en aftale om deling efter paragraph 32 eller andet følger af paragraph 26. Spouses have, a result of the law, a separate right to certain types of assets. They don't have to be a part of the division of community of property. This could include personal effects, personal compensation, or pensions. Spouses may by agreement change the division of community property completely or partially in regards what must be included in the sharing of the community of property. In the case of a prenup, spouses may agree on a separate community to the extent that they wish and can agree on. Separate community can also be determined by third parties, for example in the wills.
Okay, so theme 2.2 is called separate control. So despite two people being involved in a marriage to each other, they are economically and juridically two independent people who can make arrangements regarding their assets and debts by themselves. In the case of assets, it's called separate control, which basically just means that the owner of the asset fully governs the disposition of said assets. And these rules governing separate control last as long as the marriage, given that there is a community of property. Right, so we distinguish between 3 exceptions. First one being to real property, second one being in terms of unlawful deterioration of the community property, and the third one being in terms of co-owned assets. Right. So main rule to remember is that separate control means that each spouse can unrestrictedly, freely dispose of his share of the community property, which includes both assets and liabilities he or she had prior to the marriage, and also what he or she acquired during the marriage. So the spouse who owns the asset can freely dispose of it, for example, through mortgaging, unless and is the only spouse allowed to do that unless the other spouse has been given permission, for example, through a power of attorney stating that he too can freely dispose of this asset. Right. So some important legislation to remember is paragraph 6 of ægtefælleøkonomiloven, which is the paragraph that governs the exception of separate control in terms of real property, specifically in terms of the married couple's permanent residence. So we could come up with an example of this law. So let's say that I and Sean here are married, and I own our permanent residence, which is the house we live in for 10 months of the year. I cannot just sell or mortgage the house without getting his consent. And this paragraph was basically just made to ensure that the other spouse does not get deprived of his or her home unless it has been agreed upon, thus meaning that I cannot just
sell the house without letting him know or having us agree upon it. So if we also lived in a summer house for the remaining 2 months of the year, that would not be included in this, seeing as it is not our permanent residence. Also important to remember is that this paragraph is only applicable if the permanent residence is comprised in the community property and that it is located in Denmark. Right. So paragraph 8 of the same law is actually linked to paragraph 6, which basically states what happens when a spouse has disposed of the permanent residence without consent. So in this case, if I were to have sold our permanent residence to a third party without his consent, then he could have that sales contract or agreement invalidated within a certain time frame, given that the third party that I made an agreement with was in bad faith, which means that he knew or ought to have known that no consent had been given by the other spouse. Right. So if, however, if the third party was in good faith, the agreement will prevail, thus meaning that the agreement cannot be invalidated. And this is also where we include the concept of extinction, which means that the new right of an asset prevails the older right of the asset due to good faith by the third party. So important to remember with this is that consent is not required to be in a written format. Also, if the third party was in bad faith, the real property would just be returned to the owner spouse's share of the community property again, as if there never had been an agreement at all. Right. So another paragraph that's also linked to this is paragraph 7, which is applicable in situations where the non-owner spouse refuses or is incapable of making a decision. In this case, the state administration can give permission to sell without the other spouse's consent. And this is, for example, relevant in situations where one spouse suffers from dementia or Alzheimer's or something similar, which makes them incapable of making a proper decision. Great. So the second exception was in terms of unlawful deterioration of the community property, and this is evident in cases, for example, where the private consumption is way too large in comparison to the spouse's economy. In these cases, one spouse can claim compensation due to the other spouse's deterioration of the community property, of course. And this is only possible in situations of a division of community property and, of course, in relation to a divorce or a separation. But we will be elaborating on that further. Right, so the final exception relates to co-owned assets. In the case of co-owned assets, it just means that both spouses fully own the asset together, thus meaning that they cannot freely dispose of it by themselves. Right. So there are also cases where the owner spouse has handed an asset over to the other spouse. And in these cases, we look at paragraph 11. Okay, so to explain it, so let's say I hand over a washing machine to my spouse's business. I still own the asset, but I just give it to him. But he makes an agreement with a third party, and in this case, I would be bound by this agreement. In the case of extinction, thus meaning that if the third party was in good faith, his right will prevail over mine, despite him not having gotten any consent, as he does not own the property. I still do. I just hand it over to him. And this is especially evident in cases of assets like business chattels, for example, machinery, a washing machine, or whatever. And this rule is applicable for assets that are included in the community property, as well as the separate property assets.
Next, we'll be talking about presents, and the transmission of an asset can only be characterized as a gift if there's an intention of gifts present, which means that the gift has to be given without any demand of a quid quid pro quo, meaning that there's no expectation to get something in return. And a gift leaves the giver's property, regardless of it being from the giver's community property or separate property. However, there are some issues with the concept of gifts in relation to the interest of creditors. This is, for example, prevalent in cases where the gift being given transfers a larger value from one spouse's property to the others, as this can interfere with the interest of the creditor. So if the gift has been in disparity in relation to the giver's economy, or that the gift was given to ensure values against the creditor, also called Cornerfinden, the creditors can intervene by having the giver declared bankrupt or try to have the gift invalidated. And the gift will be included in the recipient's community property unless that there's been given a prenuptial agreement stating that the gift shall be a part of the recipient's separate property simultaneously with the gift being given to the recipient.
Separate liability, særhæften. Whether two people are singles, have just been married, or have been married for a long time, the rule of separate liability applies. Marriage and its community property really have no bearing on the individual's debt. Physical persons are only liable for debt that they have committed by themselves. And the general rule is that each spouse is liable for his or her own debt with his or her own assets. We have a law, lov om ægtefællers økonomiske forhold, paragraf 3, and it states the following. Under ægteskabet hæfter hver ægtefælle med sin formue for sine forpligtelser, uanset om forpligtelserne er opstået før eller under ægteskabet. And this means that one of the spouse's creditors cannot make a pledge on the other spouse's assets when the debt is only created by one. There's one expectation to the special liability that concerns skat. According to the Danish tax legislation, the tax administration, skatteforvaltningen, has the possibility of collecting tax debt from the other spouse. However, this only applies to tax debt that has arisen during the marriage, and it should also be mentioned that it's only possible if skat has been trying to collect the tax debt from the spouse owing the money but without any success. A spouse who is personally liable for a debt is liable for all that he or she owns, regardless if it's a share of community property or a separate property. And it's important to mention that creditor's claims against a person comes before a spouse's claim for the share of community property assets. It can be difficult to know with certainty which of the spouses who owns an asset, and the spouses can both argue that the asset is theirs, which is important in cases of sharing of community property, for example. Especially it can be difficult to determine who is the owner if the asset is purchased with cash payment. But as a starting point, it's the person who has paid that is the owner. This will usually also apply in cases where the asset is purchased by one of the spouses but is in the other spouse's name. If there is an actual registration of ownership, it can be meaningful, but it's not necessarily decisive proof. If it's impossible to determine who actually owns an asset, it will often be assumed that the asset is owned in a joint venture, so both spouses owns the assets together. This will be assumed else, for example, the fact that the purchase price of the asset is maybe raised with common money if they have the same accounts for money. And this implies in cases where the couple have received gifts, for example, such as wedding gifts. If both spouses have been taking debt together, for example, both have been signing as debtors on a purchase contract or a banking loan, then a common debt arises, and in such cases, the spouses are normally liable jointly, which means they both have to have the responsibility to pay the debt.
So theme 2.5 is called marriage termination, also in terms of more specifically in terms of division of the community property. So already in situations where a marriage couple is deciding to separate, most of the marriage's legal effects would expire. That's meaning that, for example, the community of property and support obligation is no longer valid, and there must be conducted a division of community property. And we look at paragraph 5 of ægtefælleloven to that which states this division. Right. So the division can happen in two different terms, in quantitative terms or in qualitative terms. So in quantitative terms, basically means that there must be conducted an equal division of the community property, which is done through a division of community property statement. And everything a spouse has a claim of in this division is called the share of the community property. So in terms of assessing value of these assets to define the community of property, the asset's actual value is used, and it is the sales value to a third man that is the one being used. So also pensions property is not prima facie included in the division. A prenuptial agreement must have been made if the spouses wishes to have this included. Right. So in the case of pure divorce separate property, a division is not necessary. Also, in terms of debt's role in this division, we look at ægtefælleøkonomiloven, paragraph 29, which basically just states all the terms there. So in terms of qualitative terms, we have a concept called the practical division, which is basically when the spouse who has brought an asset into his or her share of the community property, he or she has priority over it. In this case, the share of the community property assets value, if the share of the community property assets value exceeds the share of community property requirement size, the spouse must either yield certain assets to the other to make up for the difference, or after agreement with the other, buy him or her out of it.
Okay, so there are a few rules of exception that apply. The first one is called cross-designation, and an important term to remember here is the interest of the children. Essentially, cross-designation just means that if one spouse has been granted custody of the children, but not of the residence, this spouse can rely on his or her right of cross-designation, which would enable the spouse with custody to actually get the residence in connection with the division, given that that spouse can afford it. And this is basically just to protect the interests of the kids, which must be considered if it is economically possible. Right. So another rule of exception is called creditor protection. And paragraph 30 basically just describes this, and it states that a spouse must always have enough means to be able to pay back his or her creditors. So in terms of shared debt, we look at paragraph 56, where the creditor protection is also evident, as it allows each spouse to demand that the other pays back their share of the debt, or that there is some kind of provision of security for the payment, so that you can ensure that the creditor gets back what he's owed. Right. So another exception is called unequal division, which is found in paragraph 33. So in this case, it is basically just when an equal division is deemed unfair. For example, due to one spouse having a larger community property, whereas the other one does not, and also if the marriage was short. And if the marriage was short, is also important to remember. And basically, a short marriage is a duration of less than 5 years. So the wealthier spouse can be granted permission to keep a part of or the entire part of their community property in this division. This is, for example, evident in cases where, in cases of gold diggers, where young people marries an older guy for their money. So this paragraph kind of limits their opportunity to do that. So another rule of exception is called compensation for improper depreciation of the community property, and we look at paragraph 40. So if one spouse has committed improper depreciation of the community property, the other one can claim compensation for this, given that that the depreciation is of material importance, of course. This is because that a depreciation of the community property would result in the other spouse getting a smaller share of the division, smaller share of the community property. Right. So another exception is called compensation requirements, and we'll look at paragraph 41 for this. And this basically just allows one spouse who has contributed to the other spouse's property that's not being included in division to seek compensation for that too. Right. Also, we've got the exception of which is called unequal division due to fairness, and we look at paragraph 42 for this, which basically just ensures that one spouse does not get placed unreasonably in terms of economic respect in the division. And furthermore, we look at paragraph 45, which is in terms of a significant difference in the pension plan, where this paragraph allows the other spouse to get compensation. And this is, for example, evident in cases where one parent has been a stay-at-home parent, thus causing a significantly smaller pension plan while the other one has been employed, which would cause them to have a bigger pension plan. Right. So those were all the rules of exception that apply. So in terms of a division in relation to the death of a spouse, the same rules as a divorce apply.
Cohabitation. Two people are living as cohabitors if they live under the same address and live together in a relationship that can be compared with a marriage. There exist no laws, like there do in marriages, that regulates cohabitation relationships, but there are certain individual determinations concerning cohabitation, for example the Rent Act, the Heritage Act, and the Social Act. In contrast to marriage, in cohabitation relationships, the following does not apply. For example, there is no automatic inheritance rights, there's no community of property and equal division, and there's no protection of sale of mutual residence if the cohabitation has to terminate. Which is why the three acts, as mentioned, the Rent Act, the Heritage Act, and the Social Act, have been made. The Inheritance Act contains provisions that makes it possible to create an extended cohabitation testament. This means that cohabitors can insure each other in cases of, for example, death, so they have the same rights to inherit as married couples have. And also, if cohabitors have one or more children, an extended cohabitation testament is especially important, as the couple don't have legal rights to inherit each other, which means everything will go to the children. If a cohabitation relationship has to terminate, there is no division. One can compare the economic relationships between the two parts as separate property. Though some assets can be co-owned if both parts in the cohabitation are on the contract. But it can be risky to adjust in a way where only one part buys and owns the durable assets, such as like houses or cars, while the other one pays for the ongoing expenses like rent and food. Because in division of assets, only one party can take the assets with them while the other one is going without nothing. And therefore it can be a good idea to make a cohabitation contract.